The last stretch of your weekend report, let's get into it. The Commission for Conciliation, Mediation and Arbitration has ruled that decision by an employer to suspend an employee for refusing to vaccinate against COVID-19 was substantially fair. This comes on the back of several companies implementing a COVID-19 mandatory vaccination policy. The reason for the ruling was based on the fact that the employee was refusing to create a healthy work environment. For more on this, we are joined by Labour Lawyer and Mediator at Deale Attorneys, Patrick Deale. Thank you so much for joining us this morning, Patrick. Let's quickly speak about, well, this is of course a case-by-case basis, but talk to us about some of the merits in this case that saw this employee officially fired.
Yes, well, good morning to you and to your viewers. The outcome of the arbitration was that ultimately the arbitrator found that the employee was incapacitated from performing her job for failing to take the mandatory vaccination, and that she was incapacitated because being unvaccinated and not complying with the mandatory vaccination rule, she put others at risk, and she created a health risk for the rest of the employees. And in that sense, it was an incapacity issue, and she was dismissed for that reason.
Now, she might find it unfair. Is there any recourse that she has after this judgment?
Yes, there is recourse. She can take it on review to the Labour Court, who would examine the arbitration, the reasoning of the arbitration, and determine whether or not the arbitrator made a decision which was reasonable in the circumstances. So that's the recourse that she could possibly have.
I mean, we are now going into a period where a lot of companies are putting vaccine mandates into effect, some of them from the 1st of February. So this might be a thing that we'll see come or happen over and over again. Are there any considerations, though, that need or can be taken by the companies as well as the employers around all of this in order to find a working solution?
Well, I think in general, they probably need to have a look at the overall trends towards mandatory vaccination, which are leading towards, well, have resulted in this first hearing in the CCMA and the outcome of it, that it is fair to dismiss. So that's the first observation that they would need to make. And that as a consequence of that, they need to look at their own internal systems and procedures and determine whether or not, based on their overall duty of care, whether they should be also introducing mandatory vaccination policies and a rule to protect the greater good, and also actually be in line with overall national policy, which is tending towards herd immunity and everyone in the country being vaccinated to fend off this virus in the bigger picture and in the long term. So those, and this particular arbitration award will be a clear signal about where the CCMA, which is the entry point of decision making, is going, and is likely to go, quite frankly, into the future. And so this could become a norm. It is not a law at this point, because the CCMA arbitration award is not binding on other courts. It's an administrative tribunal. But nonetheless, if it goes higher into the judicial system, certainly the likelihood is that this precedent would be followed.
And taking a look at this precedent, do you think companies might be willing to rehire some of the employees who then do go and get vaccinated after the fact?
I think they could certainly look at that, for sure. Obviously they would come to the gate to apply for their jobs as not as entirely as newcomers, but they would go to the back of the queue, but they would have the advantage of having demonstrated whatever skills and experience and value that they could add to the company. So it would be beneficial to them. But yes, in principle, there's no reason why they can't be allowed back into the workplace. And in fact, we may even be seeing situations where, similarly to retrenchments, where if employees are retrenched for operational requirements, what employers do quite habitually is say, well, look, I'm sorry, we've got no job for you now because for operational reasons. But if one does arise into the future that suits your capability capabilities and your skills, we will give you right of first preference. So in the same way, they might apply that principle to an employee who is dismissed for unvaccinated, for breaching unvaccination with a vaccination rule, and say, look, if you get vaccinated, you've got a chance. Come and talk to us, and all will be good. Because I'm sure employers don't want to dismiss people for this reason. And valuable employees are being lost, could potentially be lost because of it. And so employers would probably welcome the opportunity to let them have another go if they decide later, after the event, to comply with the rule.
Is there an absolute ruling that could be made in regards to, the constitutional rights of South African citizens versus the rights of the employer in terms of health and safety within the workplace? And how important would such a ruling be, just to shed the light and to essentially have this in black and white?
But first of all, on the first part, whether there's an absolute rule, in legal parlances, the rule can be absolute. In other words, the rule can be definite. Thou shalt be vaccinated. That's a definite rule. How it's implemented, though, is not necessarily absolute, because one has to look at the particular facts of the case and examine them against the rule and the principles and the processes and procedures. So in that sense, the outcomes may not be absolute. So it's not a slam dunk that you've got a rule and you don't get vaccinated, well, you're going to get fired. Because as happened in the current case that we're talking about of the CCMA, for example, the rule that was established was mandatory vaccination. But what they did, and this is after 3 months of consultation, by the way, with the employees who bought into the policy and accepted the policy, agreed with it. They then implemented it. They then introduced an exemption clause in the policy that said, look, if this goes against your constitutional rights, we will respect your constitutional rights and we will give you an opportunity to argue your case, whether it's because of bodily integrity issues that you don't want to be vaccinated, which was the case in this Gold Rush CCMA arbitration award we're talking about. Then talk to us. What we will do, we will try and accommodate you. You can work from home if possible, or we can put you in a place at the office where you're not going to come into contact with people, or you can have regular testing, etc., etc. And if one of those opportunities to accommodate works, well, then we'll keep you on. We won't fire you. In this case, just on the facts again, this person was not someone who could work from home. She had to go and see outside business. She was a new development operator, so she had to meet new people, new clients, to bring in new business. So she was out and about meeting members of the public, apart from employees. And so it was impossible, in her case, to accommodate her by one of those means. And so, insofar as absolute is concerned, the rule can be absolute, but its application may not lead to an absolute, definite outcome. And that's what arbitrations and law is all about, to determine principle against the facts and make a reasoned judgment, fair judgment in the context of labor law and what the outcome is.
Of course, you can't, you don't have a crystal ball and you can't look into the future and see what, if she does decide to take this on review, what that would look like. But in your professional opinion, what do you think that outcomes could possibly look like?
I think it'll be the same outcome as the arbitration and award. In other words, it would be substantively fair. And the reason is that there is a rule, and the rule is reasonable. The first thing one needs to, the first bar to determine whether a dismissal is fair, in other words, where there's a good reason for the dismissal, is whether there is a rule that is reasonable and the rule is legitimate. And in this case, the rule was reasonable and it was legitimate, because not only because everyone bought into it, because it's, in effect, it's become national policy in a sense. Would it's even become international policy? I mean, look at Novak Djokovic, for example, can't play tennis in Australia because he hasn't been vaccinated. And that's another example of the marginalization of people who make their personal choices and they don't, but they got to take the consequences, unfortunately, of those personal choices. And so I think that the trend is definitely going to be towards mandatory vaccination, and it may even become law quite soon, actually, in this country. There's lots of talks been going on at Medlake between Labour government and employers about introducing mandatory vaccination, and it may become a statutory law, a compulsion nationally in a matter of weeks, and it may be going to the Constitutional Court to have a look at all of this and to say, well, is it fair? Is it reasonable to have mandatory vaccinations? A, and secondly, in what circumstances and how can mandatory vaccinations be accommodated or regulated to accommodate constitutional rights for bodily integrity, religion, whatever. And so I think that's coming down the line, and that will make it inevitable, I think, that this arbitration award would be upheld, will set the pattern for the future, and that this will become the norm in the future. And somehow, as a collective, we have to take control of a major health issue that may not be over, and it may reproduce itself going into the future into more dangerous viruses than the present one that we have. And that's the big idea. And individuals who swim against the stream are entitled to do so, but there will be consequences for it, for doing so, unfortunately. So they've got to weigh up the risks of doing it and make their personal choices and accept the outcomes, I would imagine.
Yeah, I have to take responsibility for those choices. Thank you so much for weighing in on this topic this morning. That was a Labour lawyer and mediator, Deale Attorneys, Patrick Deale. Really appreciate your time this morning.